Well, good morning, everyone. I wanted to jump on here this Veterans Morning and talk to you because if you are going through a child custody suit, you probably aren't out joining and enjoying the parades or celebrating the holiday right now. While you do appreciate your veterans, you also know that they fought for you to have these freedoms and these parental rights. And some of you have hearings tomorrow that you have to get ready for. So I'm here with you today to go over something that's been bothering me that I've been dealing with the last couple of days. Hi, Patty. Actually, for a long time, but it's come up more and more the last few days, and that is parents being asked to agree to modification in order to settle in their initial round of litigation. And then, of course, as you all know, we deal with tons and tons and tons of parents and their attorneys in modifications where they are actually trying to get that modification that they were promised would be available to them later down the road. So there's a couple segments to this live feed today. One is the first round of litigation and what you need to consider before you agree to a parenting plan that you feel violates your rights. One of them is you need to know what's involved in modification. If you're only agreeing because you think you are going to be able to modify, then you need to go and study the modification process, look at your statutes and what they require of you to get that modification, how long the statutes require you to wait before you get that modification, and then look up appeals to see who has actually been successful. And then, even most importantly, you need to contact people and ask them how much it costs for them to get that Sorry about that. My computer's holding my phone. So I think most importantly out of all of this is the expense. A lot of you are agreeing to settle because you feel that you no longer have the money to continue in the litigation process. And so if you really look at modifications as later down the road an option, I'm going to tell you they are not cheaper. In fact, sometimes they can be even more expensive than the first round through. You might think, well, maybe I'll be in a better position financially, so I can take on that expense, but you're still also going to deal with the same arbitrary, overbroad exercise of power, abuse of power that you're dealing with now. You're going to deal with the same arbitrary, overbroad statutes, right? I know some of you that have been learning from us will argue, well, then those aren't valid law. You are correct, but they are still things you're going to have to deal with. So you still have to be able to afford to fight that. So, how is it any different than fighting it in the initial time around, right? Why do you want to keep going back and litigating, causing yourself more stress? Your child's still in limbo because they know you're still trying to fight to get them back into your life equally. So, modifications have some other caveats to them as well. And that is when you go to modify, they're going to look at the pattern your original order set. They are going to look at what was addressed in that original order. And original orders, they go and they supposedly they look into the future. So the reason I jumped on to do this live this morning is because I was looking at one of those agreed parenting plans over the past week, and we actually discovered a couple of things. And I don't know why their attorneys didn't see this or don't tell them, but we actually discovered that that parent actually was primary. They didn't need to go and modify. I see that so many times. I mean, they didn't know it because there were provisions in their order, and for whatever reason, the attorneys missed these and didn't realize that modification was not the route to get the resolution that this parent needed. But what I see is most attorneys just defaulting to that, right? So not only do they default to it when you're going through the initial litigation and tell you just to settle, you can always modify later. But then when you go back, of course, that's the default they go to. Well, let's file for modification instead of filing for, let's say, contempt or enforcement. So you guys need to be responsible and read through these orders before you agree to them, see what you're agreeing to. If you have addressed things like moveaways in your orders and then the parent actually does those things, then instead of going to modify to be able to exercise your rights, you enforce, right? It's a no-brainer, but you as a parent get stressed out and defer to the attorneys as if they're going to do this job, which they should. Like I said, I have no answer why these things aren't being done this way. But once we addressed it and presented it, that is the way that they're doing it now. Um, Unfortunately, if you've already filed something, that means you have to backpedal and other things could have taken place, like temporary orders and things that you have to try to undo. So that's why we're trying to get you guys to not make the mistake initially, because every mistake costs you. Kind of look at it like building a house. When you go to build a home, let's say you're using a builder to build it for you. If they make a mistake or they put something in your home that you change your mind on or you don't like or it didn't turn out the way you wanted, it costs you to fix that mistake or make that change, right? I know when I built my home, every change was another $1,000. Well, this will cost you money as well. Every request to the court costs you money. So make sure you know and understand your order before you agree and before you go to quote unquote modify, okay? The other trap in modification is now your requirements to change whatever patterns your original order set in place are higher. Now the burden is on you to prove that there's detriment or your child is endangered with that other parent beyond what you've addressed in the original order, right? And you have to prove those things. So, hey, thanks for joining me. Um, I'll look at your questions as soon as I finish giving you all of the things that I want you to think about before you agree to settle in your final litigation or before you file a modification. So, should you agree to a final order because you think you can modify it later? Well, these are all things you need to consider, right? The other one is burden sorry, we did change circumstances, we did burden of proof. The other one is protections in the statutes while modifying. So let's say you're going to go and or let's say you have an order in your favor, because we do have parents who follow us like that, and the other parent modifies or you modify because there's something not being followed, like educational clause, instead of enforcing. Look in your statutes. You might have a statute that says primary custody cannot be changed in a temporary order. If that's the case, you need to make sure your attorney is aware of that and that they're protecting that for you. You may think that your final orders don't help you, but you got to check the fine print, right? Generally, they'll have things in there addressing geographic restrictions. Happens if one of the parents move out of the geographically restricted area. It'll usually also address what happens if you move. Let's say you're not primary and you move out of the area. It may lift the geographic restrictions on the other parent. So don't blindly go into modification thinking, aha, I got you, you moved, but then forget that you moved too. So if you want to hold the other parent to something, you need to hold yourself to it as well, especially if your order addresses it that way. Okay, so protections in the statutes. temporary orders during modification. The other thing, modification can feel like you never even had an original order. If you really just let attorneys take over the entire process, they will treat it like it's a brand new case, and you will feel like you wasted thousands, maybe hundreds of thousands of dollars the first time through. This is why you have to look at what you have and protect the parts, or protect as much of it as you can, that you've already litigated and that you've already settled on what the resolution will be when the two of you are in disagreement. Now, where this hurts non-primary parents is generally you have agreed to less time with your children. So you might have agreed to something in your statute called standard possession orders, every other weekend orders. And so what could hurt you with that is when you're going in and trying to make your equal protection, sorry, not your equal, your equal possession argument saying that you're entitled to equal, and you already agreed that it was in your child's best interest for you to have non-equal time. That's what's happening with parents who come to us. They're running into difficulties trying to make that argument. And some of you will try to make what the court sees as a collateral attack on your order, which is extremely technical. You can do those things, but like I said, not generally without an attorney, and they're not usually very successful in child custody cases because most of the stuff that occurred was random and arbitrary in the first place, right? So first you have to get your case into the right framing, but we're not going over that today. I just wanted to throw that out there. So let's think through this. You're not being told everything when you're being told to agree to modification. Can we all agree on that? Right? If you agree, just note down below and let me know if you are in a modification or if your attorneys are telling you to just go ahead and agree that you can modify later. Um, so what else do you think you need to know, or you want parents to know what happens in modifications, right? A lot of times non-primary parents who go through it end up losing more, right? That's another thing that happens. Most parents don't realize that the final order sets the bar. They think they're starting all over because when they get into modification, it seems like they had no orders at all. They can force you right back into the same expensive process that you started with originally, that you bailed on in your agreement, or you thought you did, right? They can start appointing expensive court-ordered people. You might think that you just needed to build up more evidence and that you didn't have enough originally, and now in your modification, you've had time to collect more, and you think that makes a difference, which it doesn't, because you already tried that originally. They go back and they look at those motions that were filed, the complaints that were filed, and they'll say that those were already litigated. So that's why a lot of parents are frustrated. So they may not even consider it a changed circumstance, even if the parent has continued the behavior that you were complaining about originally, right? So don't think you can go back later and just pile on. The other thing is you'll need to pay a retainer to an attorney again. So how many of you can afford that? If you've already paid that retainer, make it useful now, right? Make your first time around as useful as possible. Um, so the change circumstance proves to be a big, big, big problem for a lot of parents. They'll even let you go through a full trial, by the way, and then say you didn't have change circumstance. So they'll go ahead and take your money and let you spend yourself into bankruptcy and make you think that you're being heard when all of these provisions apply and you're just not being told. So that's why you're frustrated and you feel like later you didn't get heard, and then later they start blocking you when you want to file things that, oh, wait a minute, I think I didn't quite tell you this or tell you enough of this, or maybe I just needed to change a few more things and let me go try to modify again. Those are all traps. Okay, so what do we do? What's the difference? Why do you want to come to us to help you with this process? First of all, you can go and you can study case law. A lot of the principles that come from case law come from the 17 and 1800s cases, right? The but the issue is not just knowing case law, because you can learn excuse me, you can learn due process um, of law clause arguments. You can learn equal protection arguments. But what's happening with parents and attorneys is they're having trouble applying them to family law. So the benefit with working with Ron is he simplifies things. He doesn't just create shortcuts though. He actually has breakthroughs. I was reading a brand new constitutional book published here in 2019, and they had they go over a bunch of case law, and they teach you what the basic premise was for each case, like whether it was equal protection or economic or sterilization, eugenics cases, and things like that. And they go over a particular case that they say the case is Meyer, and they say that that case is now being used under First Amendment principles, which is not correct, which is actually what Ron has been pushing for. And the reason I say it's not correct yet, perhaps maybe they got the idea from some of Ron's materials, because he has been pushing for years to make the argument that parental rights are protected by First Amendment, but it has not happened yet. They have not actually integrated First Amendment, and the reason I say it hasn't is if you look at Troxel, Troxel mentions Meyer, and Troxel only argues your rights as a liberty right, your parental rights as a liberty right. Um, and they mention Meyer, right? Well, Meyer also argues your parental rights as a liberty right. And we'll explain more how this transition or integration and transition is actually made in our membership site. If you take Ron's course, you will have that information, because it's pretty key to your argument, right? So let's take a look and review again. The initial process that you're going through is to get a final order with a parenting plan that protects your rights. So if you're in the initial process and you're being told to agree to the whatever parenting plan is, and you're unequal and you're paying child support and you're not getting to see your kids more than every other weekend and being told that you can file a modification, now you know there are more things to consider that you need to ask your attorney about before you do that, okay? Because now you know you're not going to be able to bring up the same issues that you're trying to bring up now. You're going to let those go. You're going to waive those issues. Those are going to become more and more difficult to litigate later. So if you truly believe in these rights and you want these protections and you still have the opportunity to do it the first time through, you need to stick with it. And if you need some more powerful leverage and you need to reposture and reframe your case, that's what we're expert at. That's what we help you do. We have been helping parents recognize areas in their orders that would help them not need to modify, that would even things in their orders that show that they are primary, and things that help them get out of these courts and use the orders that you already have to your benefit. If there's benefit in there, we'll help you find it. And the other part is we are not lawyers, so we can't represent you. We don't practice law, and we're not a substitute for an attorney. We are an addition to your legal team to help you and your attorney look or find these gold nuggets in your situation to help you so that you and your children are protected, you and your finances are protected. That's what we do. So before you agree on that final order, make sure you understand there's lots more things to consider. And we'll be doing a workshop on this, so I hope you join us. The next workshop's actually tomorrow, actually not a workshop, a webinar, and that one is going to be on getting rid of the guardian ad litem or the amicus in your case. We have another sample motion, sample arguments to help parents ask for this from their attorneys, and that's going to be tomorrow evening. So go on to our website, fixedfamilycourts.com. I'm going to put that on the home page so you will know that we will be having that. I think we're going to be doing that 7 o'clock Central. Let me think here. 5 o'clock Central time. So that's going to be 8 o'clock Eastern time. Um, so also, I wanted to mention another couple quick things, and that is, remember when you're using case law, you have to associate that case law with your circumstances. So if you're going to your attorney and you're using our arguments and there's case law in there and you have questions about how to communicate that to your attorney, get in contact with us. And keep in mind that in general, the whole thing about this, if you want to put it in a nutshell to the attorney, is that best interest factors are arbitrary and they cannot possibly be valid law because they violate due process. So if you want to know how to walk through that, you need to get into our courses and our membership. And I hope that these things help you make better decisions. Hi, Tammy. I'm going to look at your questions now. Um, Yeah, that's true. So small towns can be an interesting character. But by the way, Tammy, we have had a lot of success in small towns with making these arguments. If you have a smart judge, they will respond to these arguments. If you have a corrupt judge, they may try to punish you. And that's the other thing. Thanks, Tammy, for bringing that up, small towns. The other thing I wanted to bring up to all of you is you may have an attorney who may or may not file arguments for you or fight for you on based on your rights that you learn you have. So you have to learn it yourself because there's an attorney who filed something for a parent who's now bailing on the parent, and the other side has filed for sanctions. So you have to know and be prepared that they could ask for sanctions. They could even get away with it. The judge might be just as corrupt and may decide that they're going to punish you. And sorry to hear that, Tammy. I know so many of these judges, they're just continuing with the same patterns that have been set for many decades. And that's because they've continued to get away with it, right? They're not being overturned on appeal. Most parents don't put all of these arguments into the record, or they don't protect the arguments properly. So they continue to um, get away with the abuses and the abusive practices. And thanks for showing up, guys. But it looks like I'm going to have to cut off here. Thanks for joining me. I hope that you will visit me at fixedfamilycourts.com. I hope that you will get a membership and that you will learn how to protect yourself from these additional expenses, and that you will learn how to make the arguments yourself so that if you don't have somebody to do it for you, you can push for change in this process. And by the way, it is people fighting for these rights that make these changes. We wouldn't have rights today if people didn't keep fighting, regardless of whether or not they get threatened or punished. And we will talk again soon. Happy Veterans Day to everyone. And I hope that all of you are able to get what you need and have a better week. And thanks, Tammy, for joining me. Let's see. Don't know how to turn this off. Hmm.